You've been harassed or discriminated against at work, and now you're wondering, how am I supposed to let my employer know of this unfair work environment? Well, there's two real ways you can communicate with an employer. One is verbally, and one is in writing. But there's a better way, folks, between these two options. And the answer is, you communicate in writing, and I'm going to explain why. Hi, my name is Shant Kachunian. I'm an employment law attorney at Michael Burgess & Associates, and I run the employment law department. I've devoted my entire legal career to cases like this, cases that involve discrimination, harassment, and retaliation. There are reasons why communicating in writing is much better than verbally. Let me explain to you why verbally will cut you short. Number one, when you communicate verbally, although it's softer and easier, less tension, less confrontational, you're probably going to miss something. And for many reasons. Number one is not all thoughts might come to mind when you're having that one-on-one or group conversation. Or two, sometimes people feel shy or apprehensive or reluctant to let out all the facts so they don't rile up other people's feathers. When you put things in writing, you don't have to have that concern. Number two, we live in a time where most employers now have handbooks and have policies that require an employee to communicate in writing. So if you were to communicate verbally, you'd essentially be going against the employer's policies, and they would claim that there wasn't even an effective complaint of discrimination or harassment. The third reason why verbally communicating is not in your best interest is that if you didn't put it in writing, it never happened. Which now leads me to the reasons why communicating writing is in your best interest. Number one, it can't be denied. I cannot explain to you how many times people, lawyers like myself, will go to court and face attorneys of a company who will stand up and boldly talk to the jury or to the judge and say there was never a complaint of discrimination because there's nothing in writing. When you communicate in writing, you crush that argument. You have the proof that you communicated in writing and that you communicated about a complaint of discrimination or harassment in the workplace. Secondly, when you communicate in writing, it's undeniable as to the substance of your complaint. They can't come back and say, well, sure, this person communicated with us, but it wasn't about discrimination. It was about traffic, or it was about the weather, or it was about traveling. When you communicate in writing, the substance of your complaint is undeniable. Undeniable. The third reason why communicating in writing is in your best interest is that in the event an employer claims, we lost our files, it burned, our servers went down, whatever reason you can think of, and I guarantee you they're going to think of whatever they can, guess who has proof of the complaint? You. You have proof of it through your text messages, through your emails, through letters, through a fax, or whatever other channel you decide to communicate with your employer about. The point here is not to build a case. The point here is to provide a work environment that is free of discrimination and harassment, a safe workplace. But sometimes employers don't seem to get the message. Employers like to think we're above the law. We can do what we can. No one's going to hold us accountable. By putting your complaints in writing, they can't escape it. And you've started the process of trying to remedy a bad work environment. Give us a call. We'll talk through your case. We'll talk through your situation and try to steer you in the right direction and make things right. Thank you very much.